him here to talk to us a little about this. As you've heard from the information about this presentation, our goal was to bring habeas corpus very much both local and national. So we wanted to discuss how local custody issues interface with the constitutional concept of habeas corpus, and also as citizens of the United States and citizens of the world, we also wanted to bring this discussion to how our country is dealing with habeas corpus on a national, international level as well. And I want you to join me in welcoming Ms. Amy Mclean from the Center for Constitutional Rights, who will be talking about national and international issues of habeas corpus. Thank you very much.
Hi, I just want to say that I'm incredibly impressed by this turnout and by the organization of such a creative panel, looking at habeas from a number of different angles, and it's really an honor to be here. When I saw the original list of who the panelists were, I thought, how is this all going to fit together? And I think it's a really impressive vision, and it's impressive that this many people came out to be able to discuss what is really a fundamental issue of our time. So it's clear to me that I was supposed to represent the national and international perspective. So I do come from a very local perspective as well, which is as a human being and as a citizen of the United States, incredibly concerned about the United States' current erosion of habeas corpus for a specific subset of people that is growing every year as different legislation has come forward, which I'm going to talk about briefly, and hopefully avoiding the timekeeper standing behind my back if I can get through in the appropriate amount of time. But I come from Center for Constitutional Rights, which is an organization whose mandate is to creatively use law for social change. So over the last 5 or 6 years especially, we've had quite a lot of creative uses of the law to try to achieve social change, some much more defensive than we would have wanted to be. We're working on challenging the warrantless surveillance program, which a lot of these things I'm sure you all will know about, challenging the arbitrary detention of non-citizens who were detained immediately after 9/11, usually for alleged immigration violations, but held in very restrictive conditions, and then held even after it was clear that there was no evidence to hold them, and they had agreed to be deported to their home countries, but they were held until they were cleared. So basically they were held guilty until proven innocent, which you can imagine that's quite difficult. We also coordinate the representation of Guantanamo detainees, and that's the work that I do mostly. And so I'm going to come at this issue from that perspective. We represent either directly or as co-counsel in cases of over 300 men who are currently detained in Guantanamo Bay or have been detained at some point in Guantanamo and have since been released. These are men, as you know, who have not been charged with any crime. There's only 2 of the men who are currently detained in Guantanamo who have been charged under any sort of regulations that have been approved by Congress, and both of those men, the charges have been dropped for reasons that we could discuss if people are interested. So we have now over 350 men who are detained in Guantanamo who have not been charged, and by all accounts, the overwhelming majority of them never will be charged. And I'm just going to give you a few of the clients, a little bit of a background on a few of the clients who we represent so you can have a sense of who some of these people are. There's obviously 350 people with 350 different stories, over 350 people with 350 different stories, and there have been over 750 people there. We represent right now, and I'm just going to tell you about some of the people who are still detained there now. So these are people who have been detained for over 5 years without a trial of any sort. We represent someone who is an elderly Somali refugee who was classified as a refugee by the United Nations High Commissioner for Refugees, still not seen a lawyer in the over 5 years that he's been there, despite the fact that we represent him. We represent a man named Majid Khan, who was a resident of Baltimore. His family are asylees, and he was picked up with his brother, his brother's wife, and his brother's wife's newborn daughter, his brother and his brother's wife's newborn daughter, and detained in Pakistan for a period of time. His family members were released, and then he was transferred to secret detention in a place which we do not know about, held in secret detention for several years until there was a unique political moment where it made sense to actually transfer him to Guantanamo to be able to get legislation passed, the Military Commissions Act, which we can talk about. And he has not seen a lawyer as well, despite the fact that we've now tried very aggressively for over a year to try to see him. The reason why he has not seen a lawyer, certainly not been charged, and the reason why he has not seen a lawyer, according to the government, is that he has access to top secret information. And that cannot be shared with his lawyer. What's the top secret information that he has access to? The site where he was detained in secret, without access to anyone else, and the types of coercive interrogation techniques that were used against him. And we represent a man who was the victim of the first special interrogation plan, very coercive interrogation tactics that were approved at the highest level of the chain of command, with a document that was signed off on by Donald Rumsfeld. And this was a man who was subjected to such serious coercive interrogation techniques that he had to be hospitalized in the middle of the interrogation, get signed off by a doctor at Guantanamo before he was returned to continue the interrogation as part of this interrogation plan. The logs from his interrogation were actually leaked. Different reasons as to why they could have been leaked, perhaps to be able to justify this kind of course of interrogation techniques. That's one potential reason, we don't actually know. So I come at this from a dual perspective, as a citizen concerned about the direction of the country, and as someone who is working on the legal representation of many men who are detained in Guantanamo, many of whom we know to be innocent. We have strong evidence of, and all of whom we say that the government should just do what, I never thought that I would say this, I'm agreeing with the sheriff's office here. We want something that's basic and simple. We just want these people to be held or released based on an order of the court, nothing more. That's what habeas corpus is supposed to be. That's what it's always been. It's very fundamental. It's very basic. It does not mean that someone needs to get an entire trial at this point. What it means is that the government needs to be able to demonstrate that it has some factual and some legal basis to detain someone. The government has not been forced to do that with regard to any of these people. And so what I see in the denial of habeas corpus for the men detained at Guantanamo, and what I think is really important in terms of this discussion when we're talking about the national and the international perspective and the role of Guantanamo, is an effort to consolidate executive power, to be able to say that we do not have to be able to present the factual and legal basis for detention. All we need is to state that someone is this category of bad person from the highest level, and that has to be enough. That's the current state. Essentially the current state of the laws as it applies to Guantanamo, and the current perception of it from the executive. Guantanamo was established explicitly for this purpose. In this era, Guantanamo has existed for other purposes in other eras too, but in this era, it was established to be able to be an offshore penal colony where people could be held, non-citizens could be held outside of the rule of domestic or international law. That was very explicit from the beginning, and it's something that has been consistently pushed over the last 5+ years. So despite our best efforts and the best efforts of other organizations, including the ACLU and others, and I'm sure other individuals here who have been working on this and related issues, the government has thus far had relative success in being able to hold detainees at Guantanamo, hold non-citizens at Guantanamo outside of the rule of law. We've had some victories, and I just want to talk briefly about, and I think some of this has probably come up in last week's discussion, but the little bit of the chain of how things developed with regard to Guantanamo and habeas. As soon as detainees arrived at Guantanamo, CCR represented a small number of detainees in habeas petitions in a case called Rasul v. Bush. It took us 2 years for this case to reach the Supreme Court and to reach a victory in the Supreme Court in 2004. Now remember, habeas corpus is intended to be an effective and speedy remedy to challenge the divine right of kings to be able to detain people. An effective and speedy remedy. So 2002 we filed the case. 2004, the Supreme Court in Rasul v. Bush held that Guantanamo detainees have a right to challenge their detention in federal court. These habeas cases could go forward. That was a very short-lived victory. although lawyers have been going down and we've been able to more effectively represent people, it was a short-lived victory because almost immediately subsequent to that, the Congress passed the Detainee Treatment Act, and a portion of the Detainee Treatment Act attempted to strip Guantanamo detainees of the right to file habeas cases in federal court. We had another victory in the Supreme Court in 2006. And in 2006, the Supreme Court in Hamdan v. Rumsfeld held that the Detainee Treatment Act did not strip the detainees who had already filed cases of the right to continue to file cases. That was also a short-lived victory because immediately after that, very soon after that, the Military Commissions Act was passed. And there's information about the Military Commissions Act here, and I think you all have talked about this a little bit, but this is a really far-reaching law that was passed without much discussion on the eve of a midterm election where there was great concern that the Republicans were going to lose a majority, and this was the time to be able to pass something expansive. And so it was purportedly to establish military commissions to be able to try detainees at Guantanamo. Of course, many of the detainees at Guantanamo, the overwhelming majority, undisputed, the overwhelming majority, the government acknowledges this too, are not going to be tried. So why is this such a corrosive law? Because one portion of it, a much smaller portion of it, strips non-citizens who are held in U.S. custody, who are either classified as enemy combatants or awaiting determination about whether they will be classified as enemy combatants, held anywhere in the world, including in the United States, of the right to challenge their detention through habeas, to challenge their conditions of confinement, to challenge their transfer even to a country where they could be tortured, to challenge anything essentially related to their detention in a court of law. Incredibly, incredibly expansive. That has had the effect up until now of stalling our litigation, and we are about to reach the Supreme Court again. There was a little bit of a shuffle that raised the question of whether we were going to actually see the Supreme Court on this issue. And if people are interested, we can talk about that. But we're expected to reach the Supreme Court by the end of this year on this question again. So over 5.5 years, this effective and speedy remedy is about to reach the court the third time, and the 350 plus men detained in Guantanamo have still, not a single one of them has had a hearing. So I just want to mention quickly some of the concrete effects of what the denial of judicial review has meant. It means that there are innocent people being detained, and there is no pressure on the government to be able to release people in a speedy way, or to be able to effectively review the reasons for the detention or the evidence, if there is evidence of people's detention. So there's dozens of people who have been even cleared for release by the U.S. government, and they're still detained in Guantanamo some months or years after their detention. There were people who were held through this makeshift administrative review process in Guantanamo as non-enemy combatants. Some of them were held for over 2 years after they received a non-enemy combatant determination. In 2002, the year that Guantanamo was established for this purpose, a CIA report said, and I quote, "A substantial number of the men detained at Guantanamo are either low-level militants or simply innocents in the wrong place at the wrong time." That's a CIA report after an evaluation of what was going on in Guantanamo in 2002. And by the U.S.'s own records, and by a report that was done looking at the allegations that were made and the information that was available from this administrative review process, only 5% of the men detained in Guantanamo were even captured by U.S. forces. 86% were captured in Afghanistan or Pakistan at a time where the U.S. was leafleting the countries with flyers saying that they would provide tremendous bounties for people who are turned over. So I have a flyer here, which I can put in the back and you can look at, but it says, "You can receive millions of dollars for helping the anti-Taliban force catch al-Qaeda and Taliban murderers. This is enough money to take care of your family, your village, your tribe for the rest of your life." And it goes on. So you can imagine Some of the people were captured were people who were caught in tribal rivalries, people who were foreigners who were picked up at a time where they didn't have a sense of what was going on and caught up in the fog of war. So one of the effects of the denial of any sort of judicial review is that innocent people are being detained and there's no review for this detention. Another is that there's no review of the conditions, which means essentially that the government can hold people in whatever conditions they want to hold people in. So the men detained in Guantanamo from, I'm losing the timekeeper here, getting towards the end, have been transferred to super maximum security confinement. Very severe confinement conditions transferred in January of this year. So these are people who are held in complete isolation without access to anything. And you have to remember that these are people who've already been detained for over 5 years with no charge and no prospect of being charged. So I'm going to give you one quick example of someone who was a refugee, who was fleeing persecution, was clearly caught up in the wrong place at the wrong time. Half of the people that he was caught up with have actually been classified as non-enemy combatants and released. He was cleared for release at least months ago and probably years ago. When he saw his lawyer only a couple weeks after being transferred to this condition, he said, "Tell my wife to remarry, she should consider me dead." He was someone who lost all hope being transferred to these conditions, and you don't hear about it, and there's very limited ability to be able to challenge this without any sort of judicial review. And the last that I want to mention is that there's limited ability to review and challenge the treatment and transfer. So we know that there are people who have been transferred to countries, including Libya, Tunisia, and other countries, where these individuals, because of their individualized situations, were at risk of torture or severe persecution. It's illegal by international law and by domestic law to do this, but every court that we've gone to since the passage of the Military Commissions Act has said, we don't have jurisdiction. We recognize that it's undisputed. We do not have jurisdiction to be able to do anything. It is at the executive's discretion. So because of congressional acquiescence and a limited public outcry, the administration still sees Guantanamo as an acceptable avenue and a viable alternative to the rule of law. And in fact, over the last year, almost 20 people have actually been transferred into Guantanamo. These people who were transferred from secret detention facilities and from an operation known as Operation Enduring Freedom, Horn of Africa. And so at the root of this issue, I just want to emphasize that Guantanamo exists to push and test the limits of executive power. And this is exactly what habeas corpus stands for, is an ability to check that executive power and make sure that it is not limitless. Thank you very much, and I look forward to the discussion with all of you.